Hello, XRP investors. I wanted to make this quick video in these trying and scary times. A lot of us who are ordinary investors have looked at the technologies in the American fintech market and have selected XRP as the cryptocurrency that makes more sense. And the SEC filing of a suit is devastating to us. My name is Reggie Mabry. I am a former pro se litigant, and I'm going to give you my take on the Securities and Exchange Commission suit against Ripple. My title is that the Securities and Exchange Commission cannot prevail against Ripple Incorporated. A 12B6 motion, in my opinion, is warranted to dismiss the case, if not in its entirety, partial. The SEC case against Ripple fails against their own case against a company called Telegram Group that they sued. And so the precedents are different. And so let's talk a little bit. Well, my disclaimer, this video is for entertainment purposes. It should not affect your investment decision on any cryptocurrency. I'm certainly not advising you to invest, sell, or buy XRP cryptocurrency, but I find the SEC suit against Ripple itself without merit. I'm not a lawyer, but I've been in federal court and I've helped others defeat the 12B6 motion to dismiss. But in this case, a 12B6 motion is warranted against the Securities and Exchange Commission. One of the cases that I'm going to bring up is a ruling on a case that I was cited where I was the plaintiff in that case. The matter is over and I wish the defendant in that case best wishes, and I'm only bringing up the case because it is cited and relevant to this matter. It's public information. Certainly not making any negative comments whatsoever on my previous matter. In fact, what they do in business is help thousands of low-income defendants needing a variety of legal and social services. In addition, this video in its entirety should not be taken as legal advice either way. It should not get your hopes up. It should not have any change in an opinion whatsoever. It's just my opinion and thoughts, and something that maybe might be helpful in just thinking about it. So I'm not trying to get your hopes up high. I'm not going to try to say that Ripple, the company, will ultimately prevail. It's just my opinion, and it should not affect your opinion, except for here's just some things to think about. On the matter of Ripple Incorporated, I am a long-term investor, and I'm shocked at the Securities and Exchange Commission's actions. The Securities and Exchange Commission did nothing to protect investors if they thought Ripple was a security. Their suit has had a devastating effect to normal everyday citizens holding a crypto that is not directly related to Ripple Incorporated. What I mean by that is that there is Ripple, the company, that Ripple does hold large amounts of a product or a technology called XRP, but what the Securities Exchange Commission did was attack the company that is building out usage for the product to hurt the price of the product that's already on the exchanges. They did this, the Securities and Exchange Commission did this while people are suffering financially and looking towards an investment in American technology. American technology has led the world for many years, and now what it seems is that the Securities and Exchange Commission is picking winners and losers in a new technology, and they're picking winners and losers. They're picking winners of technologies that are not controlled by the United States, or and so it just baffles that the Securities and Exchange Commission would pick a winner like Bitcoin or Ethereum over American a company that is building out a technology that could benefit the world and certainly help the United States dollar. Ripple itself, Incorporated, has probably the best set of lawyers, and my points are just my opinions. However, a pro se litigant could get this case dismissed. This is my opinion and should not affect the current litigation, but inform the public on several of the issues that I see could and should get this case dismissed or at least narrowed. On the specific Ripple matter, I will make a few light comments, but leave the defense to the experts. So I'll only make a few opinionated points along the way. But let's just keep the 3 points in mind as I walk through a few things. So I just added another point that I have found. So from Ripple, from Twitter, from Ripple's General Counsel, Stuart Alderati. He just posted 9 minutes ago when I'm doing this, and that's why I added it. Reminder, the Securities and Exchange complaint only alleges. Nothing has been determined. That's what courts are for. That's it. That's the tweet. So, all the General Counsel of Ripple is doing is letting you know that the Securities and Exchange Commission is only alleging, meaning there is a lot of shockwave in the market and people are panicking, but the Securities and Exchange Commission has not won its case. It's simply alleged that Ripple, the company, did these things. And unfortunately, by alleging Ripple, the company, people are thinking that Ripple and XRP are the same thing, and they're dumping XRP based on the Securities and Exchange Commission's alleging problems with Ripple XRP. And so this is a very important point that the General Counsel is making. It's just alleging that Ripple, the company, made some mistakes, and it's only alleging. What that has to do with XRP, nothing really at this particular moment except for speculation. Stuart Alderati also said, seeing lots of tweets spreading misinformation, legal and otherwise. Here are some facts. 1. First line of the Securities Exchange complaint alleges from at least 2013, years before the DAO report, yet the complaint was not filed for 7 years and the day before the chair leaves office. So, Stuart Alderati is making some points that we will see probably put in a different way in its answer or affirmative defenses, or even maybe a 12B6 motion to dismiss. And I see it, we're going to leave it up to the experts. But it's very interesting that the Securities and Exchange Commission starts off with 2013, even though there have been several issues, even enforcement during that time period, which is, or at least reporting at that time period. Stuart Arterati says, too, there are no fraud or misrepresentation claims. There is one legal question. Did certain of Ripple's distributions of XRP constitute an investment contract? We look forward to litigating that in court, improving the industry the clarity and providing the industry the clarity it deserves. So those are the three major points that Ripple has said. I may add in just a little bit about what I'm thinking, but these are the experts, and from what just these three points that the general counsel said, inside of it, for someone litigating a case, it has volumes in it. So let's just continue. Now I want to bring forth two cases to make some points about what is going to happen and what are some concepts involved. One is the Securities and Exchange Commission case against Bronson, 14F sub 3D 402 District Court, Southern District of New York, 2014. And the second case is the Securities and Exchange Commission versus Telegram Group Incorporated, District Court, New York, 2020. Securities and Exchange Commission got a little practice by suing Telegram Group. Now, the Securities and Exchange Commission has cited a case in federal court to defeat the defendant's 12B6 motion, and they prevailed. In that case, it's Securities Exchange versus Bronson, and that case cited myself in its legal standard based on a case that I had done, and the judge Castile cited what are the grounds for dismissal with a 12B6 motion to dismiss, which we will talk about, because I'm saying in this this video that a 12B6 motion to dismiss the Securities and Exchange Commission is warranted. But in this particular case, the Securities and Exchange Commission sued a company, kind of a Wolf of Wall Street type company, and the Wolf of Wall Street company, hit the Securities and Exchange Commission with a 12B6 motion to dismiss. And in this particular case, it did not work. And I just want to talk just a little bit about that particular case. But in that particular case, I was cited in its legal standard and in another part. So I was cited twice in that particular case. In the second case, the same judge that ruled in my case, Judge P. Kevin Castile, ruled on a case that should be analyzed as we think about how the SEC will argue its case in court, right? And that case is the new Securities and Exchange Commission versus Telegram Group Incorporated case. And we are going to look at that. However, what we need to know is what is going to happen in the next 20 days, right? And so it's important to kind of understand what the legal process is. And so I'm going to bring in some information about what is going to happen in the next 20 days or so. And the clock is ticking. Okay. So, when a complaint is filed, and the complaint is basically served, and so I'm assuming that this case was served to Ripple in San Francisco, and I don't. There are all these other things that happen when a case is served, like waivers and stuff like that, that gives the defendant more time. So either the case was served directly, or there was a notice of suit with a waiver, and Ripple has an additional time to answer. But normally, not normally, normally actually, there is a waiver put in, and the defendant gets more time. But basically, within 21 days after being served with the summons and complaint, the party must answer. So the Ripple Incorporated must answer, and within 21 days of being served with the summons and complaint, or as I was saying, if it has timely waived service under 4D within 60 days after the request for a waiver was sent, or within 90 days after it was sent to the defendants outside any judicial district of the United States. So, either of those two things happened. So either it was a waiver was signed, and was given, and that Ripple, the company, will have 60 days to answer. But a party must serve an answer to a counterclaim or cross-claim within 21 days after being served with the pleadings that state the counterclaim or cross-claim. So if there's any cross-claims, there's a time limit. C, a party must serve a reply to an answer within 20 days after being served with an order to reply, unless the order specifies a different time. So Ripple, the company, will serve a reply in 21 days. And so in short, basically what happens is that the defendant comes back with a answer, an affirmative defense, and possibly a motion to dismiss the case, which is usually called the 12B6 motion to dismiss. So when we look at the issues on how to answer the complaint, and this is Rule 12 of the federal law, defenses and objections. So we go to 12, and then we go to B6. How to present defenses. Every defense to a claim for relief in any pleading must be asserted in a responsive pleading if one is required, but a party may assert the following defenses by motion: lack of subject matter jurisdiction, lack of personal jurisdiction, improper venue, insufficient process, insufficient service of process, failure to state a claim upon a relief can be granted, and failure to join a party under Rule 19. So Ripple, the company, in response to the Securities and Exchange Commission, will answer, assert its affirmative defenses, and then possibly use any of the B1 through 7 strategies to help them help clarify or narrow what the motion is, or dismiss the motion right out. A 12b6 motion to dismiss can dismiss the whole claim out. But there also could be things like insufficient service of process, which I don't think the Securities and Exchange Commission would have done. Insufficient process. The venue is probably correct. I don't think there's any problem of lack of subject matter jurisdiction. So Ripple Incorporated Company may give a responsive motion based on a 12b6 motion to dismiss failure to state a claim. And I'm gonna talk a little bit about what that might be, or what is in it. So let's just bring that up if I can. Yeah, I have it here. So let's just bring this in. Okay, so the other source was from Cornell Education. So I don't want to leave out my sources. It's on the website law.cornell.edu, rules, federal rules of civil procedure, rule 12. And in this case, I want to talk a little bit about pleadings. Now, okay, this is consent. Okay, great. Okay, so a complaint can allege anything, but after years of analysis through the courts came up with a kind of a rule system to analyze a complaint if the complaint is attacked by failure to state a claim. And the rule structure, or the thinking right now, is based on two decisions in the Supreme Court. One is Bell Atlantic versus Twombly, and the other is Ashcroft versus Iqbal. And these are two different cases, but the cases basically, there is a combined ruling between these two cases, which is the dreaded Twombly-Iqbal, for anybody who's ever been in a federal court and have seen a failure to state a claim, a 12b6 motion to dismiss. If you were the plaintiff and the opposition gave you that, or if you was the defendant and you saw that whoever was trying to sue you is basically making allegations that you could attack with the 12b6 motion to dismiss. So let's just talk about what's going on. Well, in summary, the issue is, does your complaint or what you allege in your complaint, is it plausible? So plausibility is this magic word when it comes to whether or not a complaint survives or it gets dismissed, based on plausibility. So you can allege anything that you want in suing a party, but the issue is whether or not you allege a certain amount, you allege facts that would be plausible. So I'm going to just read a little bit about plausibility and just a little bit about about what happens, and just to give you understand that is the Securities and Exchange Commission's case against Ripple, or is everything plausible? So we will use this paper to construe some things about plausibility. So let me see. Okay, so lessons from a year under Iqbal and Twombly. Understanding and using Iqbal's formal framework. Iqbal articulates a clear framework for analyzing a motion to dismiss that begins with a threshold inquiry and is followed by a two-step analysis. Lower courts have begun to flesh out the details of this approach. 1. Confirm or argue the elements of the cause of action. At a threshold matter, where there is any doubt regarding the scope of an underlying cause of action, Iqbal indicates that it is important to begin by taking note of the elements a plaintiff must plead to state a claim. In some cases, a motion to dismiss will focus on the elements making the point obvious, but where the motion focuses on the facts alleged and their adequacy, parties should not be so distracted by these disputes that they overlook the importance of advocacy regarding the cause of action. Iqbal's procedure history illustrates this. In a petition for certiorari, the government has conceded that Ashcroft and Mueller would be liable if they had actual knowledge of discrimination by their subordinates and exhibited deliberate indifferences to the discrimination. There's dissenting. The court, however, disregarded this concession, deciding that Ashcroft and Mueller would be liable only if they themselves had adopted and implemented the detention policies at issue, not for a neutral investigative reason, but for the purpose of discriminating on account of race, religion, or natural origin. So in the Iqbal case, the Iqbals obviously sued the United States government and named as defendants Ashcroft and the court found that the pleadings that Iqbal did were not plausible because he could not say whether that Ashcroft was carrying out the procedures that Iqbal felt disenfranchised him on for the purpose of discrimination, or was it the purpose of investigation? So then it says the court could well have accepted the government's concession as four dissenting judges would have and disposed of the case without deciding the underlying elements of the Bivens cause of action that had it done so, Iqbal's complaint could have survived. However, Iqbal's case did not survive because he just didn't plead a plausibility argument to say that Ashcroft did this for discriminative purposes. So basically what he said was labels and conclusions. And this is the whole part of it, labels and conclusions. In the case of Ripple and the Securities and Exchange Commission, the label that Ripple violated Securities Act or Howie's Act is an allegation. We will see if that is plausible, right? That Ripple actually did these violations. We will find out that's what they're alleging, but we will actually find out if in fact that these are just conclusions and allegations. Okay, so 2, determine the facts that warrant assumption of truth. After establishing the legal baseline against which to measure the complainant, defendant should identify all allegations that it can argue are not entitled to the assumption of truth. So 2 types of allegations will not warrant such an assumption. So this is really what I was saying. You cannot argue labels and conclusionary statements. You actually have to argue facts that have enough information that will survive. On the first case, it's about confirming or arguing the elements of the cause of action. So, so in the first case is just basically the complainant Iqbal is accusing the government for discriminating against him during his I guess his incarceration during the war on terror, and that um, the Iqbal did not allege enough to survive a plausibility if, for example, there may be another reason, there may be another defense as to why the United States imprisoned Iqbal, and it may not have been for the purposes of discrimination, but it could have been for the purposes of investigation, right? And so that's the first leg. The second leg is to determine that the facts that warrant an assumption of truth after establishing a legal baseline against which is to measure the complaint, a defendant should identify all allegations. A defendant should identify all allegations that it can argue are not entitled to the assumption of truth. So, Ripple will have will decide whether or not that it wants to look at the complaint itself and attack labels and conclusions on the company and its officers, right, for things. So it says, first, courts will sometimes encounter allegations that are simply too unbelievably to accept it. In such instances, for example, where the plaintiff's allegations involve little green men, right? The defendant, and certainly Bankxrp seems to be little green men. The defendant may ask the court to disregard the implausible factual allegation. Such cases usually pro se are not unheard of, since Iqbal and some other cases. The principle that a court may disregard patently implausible facts claims is distinct from the principle that a complaint will be inadequate. If accepting well-pleaded factual allegations is true, it fails to give rise to a plausible inference of liability. So there are these prongs, and Ripple, the company, will have to deal with the little green men that the Securities and Exchange Commission is alleging. And so, unfortunately for me, I have been involved in a matter, and the defense brought a 12B6 motion to dismiss, and I was a pro se, and I fought back with everything that I could, and basically my case is the case that the matter is a precedent, and we're dealing with 12B6 motion to dismiss, and so that's some of the things that I want to talk about. But in the just to go a little further, there are some other issues that ultimately the court will assess plausibility. After identifying the allegations not entitled to assumption of truth, a defendant must show that the real factual allegations that remain have not nudged the claims across the line from conceivable to plausible. And so in this, if the company Ripple wants to attack the complaint of the Securities and Exchange Commission, there's an expectation of a plausibility assessment. So that the the company will have to Ripple the company if they decide to do a 12b6 motion to dismiss. I'm just telling you what they may or may not. The issue is what the facts that are remaining that the Securities and Exchange Commission is alleging, is that enough to nudge the court to a thinking of plausibility? And if it is not, then the case can be dismissed, or parts of the case can be dismissed for failure to state a claim, or the case in its entirety may be dismissed. So it is a strategy that the Ripple, the company, may use against the allegations, but you know, at the heart of this, and I'm going to go on and I'm going to show you a case or two that might be evaluated. But the real issue is that what the Securities and Exchange Commission is doing is attacking Ripple as a company, but also the implications is that the token, the cryptocurrency, right, on the other market, on the exchanges, is being devastated because of the allegations to Ripple. No matter what happens to Ripple, the XRP instrument will survive. Ripple is, all it's doing is, let's go to Star Trek. And I've said this, and if you can look at any of one of my previous issues on the 12b6 motion to dismiss, I talked about this with the others. In the case of Star Trek, there's this something called the dilithium crystal. And so the dilithium crystal was created and formed. It's some smart technology. But and the dilithium crystal can be sold on the market. So in the space universe, everybody's trying to get their hands on the dilithium crystal once the technology was created. In this case, that technology is XRP. XRP is the smartest digital or cryptocurrency on the market. It's fast, it's smart, it's secure, it's an incredible product. So that's XRP. Now, the company that developed it, or in this particular case, a company developed it, changed its format into another entity, gifted the technology to the new company. The new company now begins to build out warp drives that could process this dilithium crystal. So speculators on the market where the dilithium crystal is being sold is saying, I want as much as this thing, or as least of this thing that I possibly can, because I do think it's going to be needed for warp drives, or there might be a shortage of this dilithium crystal at some point. And so, but these warp drives have to run, and so if I have it, then it should be worth something. So I'm going to speculate on this. I'm speculating on the value of it, and this thing is way different than something like gold, right? Or silver. Yeah, gold could be used in jewelry, and silver and diamonds, they could be used in jewelry. They can be a store of value. But in this particular case, XRP is an instrument that has utility. Okay, and the company that can best build it out, the usage for it is the company that has on its staff people that was involved in the creation of this dilithium crystal, and so they know it the best, right? And they, this company, Ripple, is a software developer. among other things. It's building piping, and with software development is building piping. And so this particular company, in its inception, has access to the dilithium crystals. It has its own supply, but it's made a, how can I say, it mined just a one-shot amount of this stuff. So we know only a certain amount of this stuff exists. And so they have a large portion of it. But they have also allowed it to be sold on the market, on exchanges, right? And so the organization itself, or Ripple the company, seems, it's just my opinion, I may be wrong, but they went through several business structures, and so now there are foundations that control it, there's escrow, and all of this stuff has been reported to the government. And it seems like there are multiple parts of the government: the Securities and Exchange Commission, FinTech, there's so many, IRS, there's so many parts of this government. But at least to one or so of these agencies, Ripple the company has been reporting its actions. Okay, I want to look at a case called Securities and Exchange Commission versus Bronson. In this case, the Securities and Exchange Commission sued a company that it kind of titled, or it was titled as kind of a Wolf of Wall Street type company. And it's a securities case, of course. And basically, in this particular case, let's go to the elements of what a decision looks like. So this is a judge's decision. So if we were to get a decision on any element of this case, we would want to look at this format: opinion and order, maybe here, background, factual background. And so in this particular case, Bronson and E. Lionheart is a penny stock scheme that the SEC alleges, and that they make out their, the judge now is basically looking at the factual analysis. And then the judge looks at the role of the company. And then the judge looks at the procedural background of what has happened in the case. And then there is a standard of review. How is this judge going to look at this case? Now, in this particular case, Bronson and his company saw the complaint of the Securities and Exchange Commission, and they filed in the time in which they have. Remember, you have to answer a complaint, you have to give your affirmative defenses, and then any particular motions that might attack the pleadings, which is the 12B series of attacks. In this particular case, they did the 12B6 attack, failure to state a claim. And so now the judge now is looking at the standard of review of the 12B6 motion to dismiss. And this goes into all of the concepts of plausibility. And so you will see wording like, we reviewed de novo or district court's dismissal of a complaint pursuant to the 12B6, accepting all factual allegations in the complaint and drawing all reasonable inferences in the plaintiff's favor, right? So you see the judge making out the basis of what he is going to do. Then they're going to talk about what I had talked about before, the standard. What the standard is now, the Iqbal Twombly standard. And so here the court is laying out the elements that it's going to look at from the Bell Atlantic versus Twombly case, and then the Ashcroft versus Iqbal case. And so there is these prongs that this judge is going to go through to satisfy the elements. And then the judge basically now uses cases to substantiate what it knows and is going to use it as a standard of review. In this particular case, which is important, Securities and Exchange versus Bronston, they use this wordage. A court may dismiss a claim on the basis of an affirmative defense raised in the motion to dismiss only if the facts supporting the defense appear on the face of the complaint and it appears beyond doubt that the plaintiff can prove no set of facts in support of his claim that would entitle him to relief. Mabry versus this particular organization, 769F. I am Mabry. This ruling is precedent, and it was in a case that I acted as a pro se for. The case itself has no bearing to this case, except for it was a 12B6 motion to dismiss case, and I attempted to protect my complaint in its entirety based on what I knew about how to protect the complaint and to attempt to prove that my complaint was not did not have labels and conclusions, but actually were facts. And so the Securities and Exchange Commission now is using the wording of within my case to make then an analysis. So then they will go through an analysis, the federal and state registration requirements, the legal landscape. And so in this Ripple case with the Securities and Exchange Commission, they will go through the legal landscape of what is in the thinking of judges. And then they will go through specific areas of exemption, which is important, accredited investor status, and then for another reason in this particular analysis, they bring another part of something that happened in my case, some wording, and basically it says, and the court will not infer defendant's eligibility to make these investments as accredited investors simply from the fact that defendants are alleged to have illegally made millions of dollars from their scheme. See Mabry. A court may dismiss a claim on the basis of an affirmative defense raised in a motion to dismiss only if the facts supporting the defense appear on the face of the complaint and it appears beyond doubt that the plaintiff could prove no set of facts in support of his claim that it would entitle him to relief. So again, the wording from my case, or the ruling of a matter that I was involved in, applies when they are looking at the legal landscape of different elements of what the Securities and Exchange Commission is accusing Bronston, and how Bronston is now attacking the complaint of the Securities and Exchange Commission. So here they will go through the elements, and then ultimately at the end of the day, while the judge is doing this, the judge is pretty much letting you know why the judge ruled the way he did. In this particular case, this is another part, unjust enrichment of Fair Hills Capital Incorporated. You will see elements of this in the Securities and Exchange Commission's attack on the company Ripple and its officers, and then you will see the judge make comments on the claims that the Securities and Exchange Commission did. So in this particular case, the 12B6 motion to dismiss that set forth to destroy the Securities and Exchange's complaint, in this particular case, it failed. In my opinion, as I will continue to say, just in my opinion, the Ripple Incorporated, the company, has far more affirmative defenses in the context of their complaint, which again I'm going to let the experts do it. But I have enjoyed a number of videos by the digital asset investor, by digital perspectives, by everybody's man, Jungle Inc., right? The Bearable Bull, his commentary. There have been a number of very strong channels that have given us an enormous amount of information on XRP. Shout out to Bankxrp. So if you want to see where Ripple may defend itself, you're going to have to get your popcorn and look at Digital Asset Investor and Digital Perspectives blow by blow commentary. And shout out to Crypto Chiz. Bullish. You're going to have to look at some of those videos, and then you could use some of the concepts to give you an idea of how the SEC, if you've looked at the Securities and Exchange complaint against Ripple, how some of that just doesn't fly. It just doesn't fly, in my opinion. So let me just move on. I'm going to show you the case that the Securities and Exchange Commission did against a company that I think they see this as what Ripple is, but this is certainly not what Ripple is and what Ripple, the company, did, right? And this case is probably the case that the Securities and Exchange Commission is going to fail, in my opinion, because the Ripple, the company, will cite this case to show that the Securities and Exchange Commission's case on Ripple is a completely another animal. So this is going to get really exciting. I mean, talking about law is I can't listen. There's no bombs going off and no bells unless you've done a legal case and you've observed and you know the precedents and stuff like that. But what I have done for you is shown you two cases that will certainly be a part of either the judge's ruling or they will come in some of the motions, because one is one of the only cases where the 12B6 motion analysis is applied in Securities and Exchange Commission, Twombly versus Iqbal, which would be important if Ripple, the company, decides to attack the SEC's complaint. And the other one is absolutely, right, the way in which the Securities and Exchange Commission will lay out its case, and let's see what the judge does with this. In this, I just want to tell you in the next round, the Securities and Exchange Commission did win against this other case, but this other defendant is not Ripple Incorporated, right? This other defendant had some issues, and so the Securities and Exchange Commission won easily. In my opinion, with Ripple Incorporated, not so much. So let's review that case. Okay, so now I want to introduce you to the case that I think the Securities and Exchange Commission is confusing Ripple Incorporated with. So in 2020, there was a ruling by Judge Castal, the same judge that made the ruling in a matter that I was involved in on the 12B6 motion to dismiss matter, and Judge Castile now has was cited by the Securities and Exchange Commission, Bronston, and now Judge Castile gets a Securities and Exchange Commission case himself to review. And so this is the case that will bet your bottom dollar will be a major factor in looking at whether the Securities and Exchange allegations to Ripple are accurate, or if they fail to state a claim. These are some of the things, and it's a very, very important. So let's just go quickly through the elements of the case. Again, the title of the case and the defendant and plaintiff. Plaintiff is the Securities and Exchange Commission. The defendant is Telegram Group. In this particular case, there is an opinion in order for the matter, right? And in this case, the Securities and Exchange Commission seeks to enjoin Telegram Incorporated and TON Issuer collectively, Telegram, from engaging in a plan to distribute grams, a new cryptocurrency in what it considers to be an unregistered offering of securities. And then in this case, the Securities and Exchange Commission in 2018 talks about the matter. And this is important, because here in 2018, the Securities and Exchange Commission gets on Telegram really early, 2018. So in early 2018, Telegram received $1.7 billion from 175 sophisticated entities and a high net worth individuals in exchange for a promise to deliver 2.9 billion grams. Telegram contends that the agreement to sell 2.9 billion grams are lawful private placement of securities covered by an exemption from the registration and requirement. In Telegram's view, only an agreement with the individual purchasers or securities. Currently, the grams will not be delivered to those purchasers until the launch of Telegram's new blockchain, the Telegram Open Network TON blockchain. Telegram views the anticipated resale of grams by the 175 purchasers into a secondary market via the TON blockchain as wholly unrelated transactions, argued that they would not be the offering of securities. So this is the opinion in order. I just wanted to read it, but in very right off the grip, in the beginning, this is not what Ripple the company did. But in this particular case, the judge got on it really quick and made this. I just want to say something. This company, I don't think that they're English speakers, because, the flags would go up if you are selling grams in the United States. Selling grams is very close related to, yes, it's a measure, it's a unit of measure, but unfortunately it's been tarnished by the cocaine industry, right? And then the company, Telegram Open Network, is like, the acronym is TON. And so, again, they're tarnishing themselves because they don't seem to understand, whoever did this, I know that they're a foreign country. A foreign company, in the sense that the people who decided to do this were from another country, because ton, grams, cakes, all of this sounds will immediately raise the flags of anybody investigating. So right off the bat, they're breaking down of what they're selling, and they're selling these grams. They're giving these grams to the initial funders, and then they want to have these these grams in the secondary market. And so you will see in the construction of this that the Securities and Exchange Commission immediately goes out with the Howey test to this, right? Immediately will go out to the Howey test with this matter. So let me just continue on. So here's the Howey test right here. It says, now this is analysis on cryptocurrency and the Howey test. So everybody's got to read this. Cryptocurrencies, sometimes called tokens, are digital assets or a lawful means of storing or transferring value and may fluctuate in value as any commodity would. In the abstract, an investment of money in a cryptocurrency utilized by members of a decentralized community connected via blockchain technology, which itself is administered by the community of users rather than a common enterprise, is not likely deemed a security under the familiar test laid out in SEC versus W.J. Howey, 1946 case. The Securities Exchange, for example, does not contend that Bitcoins transferred on the Bitcoin blockchain are securities. The record developed on the motion for a preliminary injunction presents a very different picture here. So, wow, the Securities and Exchange Commission is picking winners, right off the rap. So Bitcoin is not a security, right? So then the court finds that the SEC has shown a substantial likelihood of success in proving that the contracts and understanding at issue, including the sale of 2.9 billion grams to 175 purchasers in exchange for 1.7 billion, are part of a larger scheme to distribute those grams in this secondary public market, which would be supported by Telegram's ongoing efforts. Considering economic realities under the Howey test, the court finds that in the context of that scheme, the resale of grams into the secondary public market would be an integral part of the sale of securities without a required registration statement. So the judge is basically telling you how it's going to rule. It's you looking at the Howey analysis, and we're looking at the 175 purchasers of grams in kind of an investment contract, and they will get some grams, and those grams will be sold in the secondary market on the exchanges, right? And so for obvious reasons, you can see that the Securities and Exchange Commission, is likely to succeed. You have your investors on one side spending money and getting a certain amount of grams, and then when the secondary market happens, then they could buy and sell those grams on the secondary market. And wow, you could see some problems with this. This is not Ripple. This is not at all Ripple. Now, again, I'm gonna say a few comments about Ripple at the end, but this is not Ripple. Thanks to digital asset investor, Bankxrp, Digital Perspective, Jungle Inc., and Bearable Bull, and lots of other good, smart crypto airy, lots of good YouTube shows. We know that this is absolutely not the case. So anyway, let's continue to go through. I'm trying to make this law stuff a little exciting. It may not be to you, but it is exciting, even for a pro se. Findings of fact and conclusions of law. So they talk about Telegram. There it goes. In 2006, Pavel Durov founded Bankxrp, a Russian version of Facebook. And then they talk about his brother. So obviously, they don't know America's politics and concepts on the drug war to be even creating a organization that is selling grams. You can't be selling grams in the United States. No how, no way, right? So now, but they're very bright. The Ton blockchain and gram. In one sense, this seems very similar to the Ripple ledger, right? and XRP, or the XRP ledger now, and XRP. So it seems very similar now. The TON blockchain seems very similar to the XRP ledger that is now run by a foundation, and XRP. They create something called the TON blockchain and grams. So again, this is very, very important, because you're gonna see how the how you're gonna see the Securities and Exchange Commission try to play the same game that it's really, well, the Ripple blockchain, like the TON blockchain, and grams for the TON blockchain, and XRP for the Ripple blockchain. And so the currently now there is a big difference on how XRP is constructed, the ledger is constructed, and who the ledgers is involved in as it becomes more and more decentralized. And so there's a big difference. But let's continue on and look at this, the TON blockchain and grams. So, okay, so they produce a white paper, and then they go on and deal with some, in 2018, not 2013, 2018. So there's some time issues that probably will appear in some arguments. But here, the Securities and Exchange Commission gets on them right now about the 2018 sales to initial purchasers. So this is where the grams are being sold. I feel so bad for them, right? Just their terminology just killed them. And so they talk about the number of grams in the deal that the investors will get, and then they will be able to use them later in the secondary market. And then they talk about the post-2018 sales actions, and then there is a preliminary injunction standard to kind of stop it before it begins. And so stopping it before it begins helps investors. Securities and Exchange Commission is supposed to help the investors coming in and doing an action on a company like Ripple 7 to 8 years later, right, where there are investors in the XRP that was put in the market. Where are the individual, where is the public? Where is the public protected, right, in such a long range? Just on the outside, I expect to see a class action suit against the Securities and Exchange Commission, against the investors, for what they did by attacking Ripple, the company, this way, has had ordinary citizens lose enormous amount of their time in the investment. Many people investing in XRP have waited 4 to 5 years for them to get any type of gains, watching the structure of the company and not seeing any negative signs of the Securities Exchange Commission. And then all of a sudden, boom, the Securities and Exchange Commission, you may say, is unfriendly to Ripple, the company, but it is far more unfriendly to ordinary citizens of the United States. But anyway, I'm just showing you how this is broken down, and I'm adding to some comments. Section 5, liability and the Howey test. So this is the liability based on a Howey test to this company, right? What the Howey test provides. Then they talk about exemptions, because the company, TON, is claiming exemptions, and so they go over the exemption requirement. They will go over the exemption requirement, if any, from on the Ripple suit too. H, the grant purchase agreement associated understandings and undertakings include the expected resale into the second market or viewed as one scheme under Howey. So here the Howey test is put on the actions of this particular company that's a defendant. But I will say right now, there was an enforcement action on FinCEN on Ripple in the early days, and then Ripple fixed that problem, began reporting to FinCEN, and then started operating by other means. And so by this time, the XRP itself, the lithium crystal as I call it, is on the secondary market being sold. The Securities and Exchange Commission, they are trying to come up with some type of analysis about how XRP uses its how they want to come to some analysis on how Ripple, the company, uses the XRP that it has to make its case. And I'm going to leave that for the experts, for Ripple to make the analysis. But in this particular case, on this suit, basically there is some agreement between the holders of the grams and what they will do, hoping to do on the secondary market once this is built out. And so the Securities and Exchange Commission, or the judge in this particular case, organizes himself in this complaint. Talks about investment of money, common enterprise. You're going to see a lot of this material in any ruling against Ripple, one way or another, right? So this case right here is the standard case, expectation of profit. You will see you will see how the Securities and Exchange Commission is attempting to run the same case on Ripple, that there's the expectation of profit by some dealings that Ripple have done using the Howey test, and but this is a completely different matter. So I'm just showing you how this is the case that everybody needs to look up. You can find it on Google Scholar, Securities and Exchange Commission versus Telegram Group, and you will find this particular case. And then what you really want to be concerned about is the construction of the ruling. And then for your own edifice education, you want to look into what you know about, what you think you know about the Ripple matter and the Securities and Exchange Commission. You want to see if this is the same story. In my opinion, it's certainly not the same story, right? This is certainly not the same story, and it's so okay. So plaintiff's motion for preliminary injunction is granted, so ordered. So the Securities Exchange Commission protects, in this case, the investors by stopping the process as it is pretty much underway. It is not the case of the Ripple matter. So what I am going to do is I'm just going to show a little bit of the complaint against the Securities and Exchange Commission against Ripple, and just make some quick points, and then I will end the video. Before I say one word about the SEC's suit against Ripple the company, I want to reiterate what the General Counsel of Ripple's the company said. So Stuart Alderati tries to inform the public as a lawyer. Reminder, the Securities and Exchange Commission only alleges, nothing has been determined. That's what courts are for. That's it. That's the tweet. If you were looking for a tweet, Stuart Alderati, while the professionals and experts are getting ready to get down to business. They just saying that the Securities and Exchange Commission only alleges. He says in a previous tweet, seeing lots of tweets spreading misinformation, legal and otherwise. Here are some facts. First line of the Securities and Exchange complaint alleges from at least 2013, years before the DAO report. Yet the complaint was not filed for 7 years and the day before the chair leaves office. What Stuart Alderati is saying there is that you will see their response about specific points that they have made in this particular really short, profound statement. And I don't know, as a pro se litigant, as somebody that's looked at cases, you might see elements of it being time barred. You might see strategies to narrow the period. You will see allegations of misrepresentation or counter claims of misrepresentation. You will see probably lawsuits directed at the SEC for filing the complaint so late, and why didn't they give guidance. Stuart Alderati is saying a whole lot in this one line. One way or another, right? There is a time issue, and that time issue has a lot to do with not the Securities and Exchange's allegations, but how they are framing it or misframing the arguments. Then Stuart Alderati says, point 2, there are no fraud or misrepresentation claims. There is one legal question. Did certain of Ripple's distributions of XRP constitute an investment contract? We look forward to litigating that in court and providing the industry the clarity it deserves. Wow. Now, when Ripple is actually, the company is actually saying this, both Ripple and the Securities and Exchange Commission knew of or approved of or transactions. I'm not going to mention any particular parties, but the Securities and Exchange Commission seems to be waiting for some, what they deem as some smoking gun. But all the while, it seems that Ripple is reporting it, letting the public know, doing many of these things up front. But of course, the Securities and Exchange Commission is alleging its points of view. And so that's what courts are for, to see if Ripple, the company, was asking for clarity with this asset, which I'm calling a dilithium crystal. And I've done another video a long time ago. Maybe I'll pull it up and show you when, in fact, that I did that video where I was talking about it. And so other people have used the term, and that's fine. But my analysis is, I don't know, somewhere around 27, really about 2018. When I made the analysis, and that was based on the other court cases when I made the analysis. But so this is what the general counsel is basically saying. I pinpointed these 3 tweets, which have enormous, which has enormous information in them. So let me go and find the complaint, and I'm not going to go too much over the complaint. I'm just going to show you the complaint. So here's the complaint. I'm not going to spend a whole lot of time on it. You can find it at SEC Gov Litigation Complaints 2020, and this is when this is their formal complaint. This is how a complaint is structured. There's the plaintiff, and this is the defendants, and they are suing Ripple Labs Incorporated. Interesting. They're suing the CEO and the chairman of the board, and they're putting their names out there as if they, it's making, unfortunately, them look as if they were criminals. And I just take issue with that. These men have been in circles with many people around the world. These men, Bradley Garlinghouse and Christian Lawson, are not criminals. These are innovators. These are the people that is looking for faster payments, more accountability in settlements. These are innovators, and here the American government itself, or a part of it, is attacking innovators. What does that say about this this government? What does this say about a portion of the government attacking innovators who are in plain sight? These are not people in the shadows. These are people who contacted the Treasury. These are people well known by many high people in the government. These are not shadow people. These are not Russians. These are American citizens, right? And they are innovators. So, as the general counsel said, you will see from at least 2013 through the present, defendants sold over 14.6 billion units of a digital asset called XRP in return for cash or other considerations worth 1.38 billion US dollars to fund Ripple's operations and enrich Larson and Garlinghouse. Defendants undertook this distribution without registering their offers, and sales of XRP and SEC are required by the federal securities laws, and no exemption from the requirement applied. And there's no exemption from this requirement applied. So they are attacking Chris Larson and Bradley Garlinghouse as crooks. And all that you've ever seen from these two men were their advocacy for this particular technology, right? But they say that they allege using words as receiving cash and other type of things, and it seems like they're dirtying them. And then it goes on about the registration statement. They never found it. Ripple engaged in its legal securities offering from 2013 to present, even though Ripple received legal advice as early as 2012 that under certain circumstances XRP can be considered an investment contract and is therefore security under the federal securities law. Okay, so they go back further than 2013 to 2012. Interesting how the government, who constructs the laws that send people to jail for a long time, take away people's freedom and people's wealth by laws, by attacking complaints of people trying to defend themselves. Now they themselves now can do something different in their matter of operations. That they can now go as far as they want and think that it's going to be legally accepted. Anyway, so let's just go down. Okay, great. So it's operating now. So then they attacking, they're saying violations, nature of the proceedings and relief sought, jurisdiction and venue, defendants. Interesting. Related entities and individuals. So they see XRP2 companies, and they are they have some pretty much unnamed people. Ripple Agent 1, Ripple Agent 2, Ripple Agent 3. That's also in this seemingly in this complaint. Statutory and legal framework of their allegations, and let's see what else is going on. Background on digital asset and distributed ledgers. This is their version of it. Now, this is the thing about it. I mean, the government has experts, and they can look at blockchains, and they can look at all this stuff. But you're looking at some of the best innovators of a smart, very technologically sound asset in a company trying to build it off and build it out. And again, and it seems like here the Securities and Exchange Commission is picking winners, right? The creation of XRP, right? You know, they don't mention some people, but they don't mention. I'm not gonna snitch, but there's some people that's not mentioned in here, right? And then Ripple begins to distribute XRP. Okay. There are a lot of cryptocurrencies that are distributed. Okay, no problem. That's what cryptocurrencies are. They're distributing on exchanges. And Ripple made unregistered offers and sales in connection with XRP distributions. Maybe so. Maybe it was dealt with. Maybe it was enforced. Maybe that happened then. Maybe there's some issues where Ripple didn't comply, or maybe there's some issues that Ripple, the company, completely complied. But the Securities and Exchange Commission is making its allegations. Overview of Ripple's XRP's distribution, so they want to get into the money to make it look like a crime. It's almost looking like a drug crime. And so I could go on and on about this type of thing, but I'm alarmed that if you're going to spend 70-something pages on this, then maybe you could have knocked it down if you would have gave some regulatory clarity and then seen if they broke the law, right? Why would you wait so late to now say that they should have known, when all they have been doing is asking for regulatory clarity so they can work among those lines? But you go back and you are looking at all of their operations from a specific time period, but you never ever want to give a company like this regulatory clarity to at least let them know. But you're saying on one hand they should have known that they was breaking a 1940 test on securities, right, in a modern day market. This is an embarrassment to the United States government. I mean, I would say that look, I mean, first and foremost, maybe hopefully during this this cycle, maybe the outgoing President Trump will give Ripple a break, give Ripple a pardon, maybe out the door, and that will stop the case. That will stop this case immediately, but maybe out the door. I don't know, but that's one issue. But if it doesn't even go that way, which, you know, I just blurted that out, it may go another way, that in fact that it goes to there's a 12B6 motion to dismiss, to narrow down some of these allegations, to prove a lot of this stuff 2014, 2013. So where's the Securities and Exchange Commission giving guidance at that time period, right? And then they are spying on, they seem to be spying on Ripple,
Ripple the company. They've invested a lot of information trying to examine Garlinghouse and Lawson's personal activities and public activities to make their case. We as citizens don't get to do that to government officials, but government officials get to monitor us for us and never hold them accountable for their statements. And this is look. I know I am a descendant of Africans born here on the slave trade. I know what disenfranchisement meant. I was born in Newport News, Virginia in '65 in segregated South. I know what disenfranchisement is, right? And this is disenfranchisement of the government against United States citizens. I know how we were disenfranchised. We were just descendants of Africa were just chattel slaves, right? To build up this economy. I mean, as far as I was saying, the black man from Africa was the first Bitcoin, right? He was a purchase of a black man was internationally settled. Black man or black woman. We were the first blockchain. The slave trade was the first blockchain. But aside, getting back to this particular point, it's just amazing how they would do this and how they know that this will affect the people who invested, hoping that if there was a problem, the government would have stepped in much earlier. And so I'm upset. I am really, really upset about how officials in this government is operating, and they're not operating on good faith. They're just not operating on good faith. This is basically trying to destroy the character of technical innovators that will probably change the way finances is done, and picking winners. To even talk about Bitcoin and these other things is picking winners that are controlled. The mining is controlled by other companies. I would say this. I mean, hopefully at the end of the day, what they're really scared of is, one of the things that they're really scared of. Certainly, what you probably don't know is that there's probably going to be a tax levied on mined coins, an energy tax. I'm pretty sure that if you're invested in these companies that have mined coins, there is going to be a global tax put on energy consumption to mine it, right? So this is just picking winners and losers in the short term. It's basically creating speculation. It's creating unnatural volatility in the market. And look, I'm gonna stop. So this is just my take. At the end of the day, I'm hoping that some group can put up a class action suit against the Securities and Exchange Commission for their actions that devastated the price of people's investment over attacking Ripple the company, and thus attacking Ripple the company, you cause some related action on the price of XRP. I'll stop. So this is my presentation, in my opinion, from a pro se litigant, that the Securities Exchange Commission has all types of problems bringing this particular case. And I've showed you standards and other cases that they may in fact use. I've talked about some strategies that the company Ripple can use, and I've given you some comments about what the general counsel of Ripple says, and some implications that deal with the world. And listen, I mean, there are lots. The XRP army. There are brilliant people. I mean there's Susie, Esoteric Trading, there's Eri, there is Digital Perspectives, there is Digital Asset Investor, Crypto Chiz, Jungle Inc., the Bearable Bull. There are just I think I forgot, VOD. There are just so many experts on what has been going on internationally on XRP. So yeah, this is going to be the new case. Really, this is not the new Howie case. The Howie case is still very, very valid. This is going to be the cryptocurrency case. I've shown you the other cases that make the standard, but attacking XRP, which was sometimes the second or third largest cryptocurrency, it seems like if anybody had some information about what was going to happen and when it happened and the ramifications of it, it was basically like a presidential tweet that destroys the market. Maybe the president of the United States can get away with it, but an outgoing Securities and Exchange Commission officer may not get away with this. Doing this at the end of the year where there's just lots of problems, anxiety, pain, and suffering, to do this at the end of the year knowing the impact that it will have in the market. So I'm hoping that there is an action against the Securities and Exchange Commission or an action against it's interesting here. Usually officers of a company are basically only sued in their official capacities, and to sue these men in their individual capacities. And I have been in federal court trying to sue on capacities, and the United States government forced me to sue only in official capacities. And I just gave some advice or helped someone with a complaint, and the Securities Exchange, not the defendants came back, and then they did a 12B6 motion to dismiss, arguing about individual and official capacity, and so most of the time the issue is only in official capacity. But in this case, they are setting out for making Bradley Garlinghouse and Christian A. Larson basically criminals. And so this is political, this is personal, this is not in the law, and I'm hoping for all of us that Ripple, the company, prevails for all of its investors. So thank you very much. My name is Reggie Mabry, and I thank you for your time, and I'm hoping that some of this is helpful to you.